Good afternoon. What's your name, sir?
Cornell McQuarrie, capital res lowercase, not the all caps, sir, which legally denotes a corporation.
Welcome to a courtroom showdown you won't believe. Today's case is a full-blown sovereign citizen circus complete with fake legal jargon, wild accusations, and a defendant convinced that he's immune to every law on the books. Meet Colonel McQuarrie, or should we say capital or lowercase, not the all cap, because apparently, even how your name appears determines your legal status. This isn't just a misdemeanor hearing. It's a crash course in courtroom delusion. As we dive into this roller coaster, pay attention to how the judge maintains control while the defendant throws out everything, from the Michigan Constitution to the Uniform Commercial Code. And spoiler alert, he even tries to reserve his rights under UCC 1 to 308 during a criminal case. This is part one of a wild ride that's only getting started. Let's break it all down step by step.
Sir, I'm sure your counsel would suggest that you not do that, but you have a right to do that if you want to over your counsel's very solid legal advice.
Judge, if I may briefly, for the record, Mr. McQuarrie did not want us to represent him. We tried to represent him. We would like to help him and represent him.
I'd like to represent myself, sir. Under Michigan Constitution 63 Articles.
Okay. It appears that you have a desire to represent yourself. Let me just ask you a few questions. You're aware that either right now or at any point while this case is pending, you can have the assistance of counsel should you so desire. Are you aware of that?
I am aware, sir.
All right, and it's your decision at this time to proceed without counsel, is that correct?
That's correct, sir. Appropriate persona under Michigan Constitution 1963 Article 613.
A right to represent yourself. You do not have the right to talk over me, sir. So let me say a few more things. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, which we've just discussed. And if you cannot afford an attorney, the court will provide one for you. In fact, we have several attorneys here today who are very capable. Of course, you can turn down that constitutional right, and it appears that that's what you're doing. Let's see, you're charged here with one count of misdemeanor assault or assault and battery. Maximum penalty is 90 days and or $500. And of course, going to enter a not guilty plea on your behalf, sir. We're going to hear a few words from the prosecutor, and then it'll be your opportunity to speak if you so desire. Mr. Prosecutor.
Thanks, Your Honor. Again, Steve Vincent on behalf of the people. The complaining witness, Your Honor, in this case is a police officer. Apparently, during prisoner transport, the defendant walked past the police officer who was in and around the area while the defendant was being escorted to the holding cell. And defendant took it upon himself to lean towards the police officer and spit on him. As a result of the defendant's actions, the people will be asking for $1,000 cash bond.
Mr. McQuarrie, anything you want to say as to bond, sir? I do caution you not to discuss the alleged facts of the case, but it's up to you.
Well, I first would like to challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. This is a structural error, Your Honor. Under MCL 767.24, Judge, this statute of limitations has told this is a structural error. This is prosecutorial misconduct under Michigan Michigan rules of professional conduct.
The defendant invokes the Michigan Constitution while simultaneously rejecting court procedures, yet somehow still participates in the proceedings. Sovereign citizens love cherry-picking legal references to claim immunity, but it's like quoting traffic laws while insisting you don't need a driver's license. And let's be honest, citing Article 13 without understanding how jurisdiction works is courtroom cosplay at best. The judge, to his credit, remains calm, allowing the man to assert his right to self-representation. But we're already off the rails. And it's clear this hearing is going to get messier before it gets clear.
2002, I was released in August of 16. Paperwork, everything. I've been filing complaints against the prosecutor's office. Kim Worthy, where a judge heard it on appeal, Kirsten Frank Kelly. It's been crimes against me by the prosecutor's office. And I would like to move for a change of venue where it's clearly documented, Your Honor. And the statute of limitations has told, I don't know nothing about this case. Why wasn't I processed or liens checked before I was released from prison? I've been home 6.5 years, Your Honor. This is a crime in violation of misconduct in office, MCL 750.505. Also 18 USC 241, 242 per the federal statute. Embler versus Patchman, the prosecutor does not have absolute immunity. Judge, and I exercise the common law. I demand that this case be heard under the common law, Judge. I've been home 6.5 years. No threat to anyone. I've been working. I have had 5 children since I've been home. I'm a grandfather. I have 2 grandchildren, 1 on the way. And I've been trying my best, and people have been calling, making false complaints on me, and it's well documented. I've tried to press charges, and the prosecutor won't do anything. This is selective prosecution, vindictive prosecution as well. It's all documented, sir. And I ask that this case, I would like again to challenge personal subject matter and territorial jurisdiction. Under MCL 767.24, the statute of limitations have told. They have been notified of any pending warrants or anything else while I was incarcerated before I was released. I've been home 6.5 years, haven't been a threat to the community, haven't been a threat to anyone. People have made false complaints on me, and I filed police reports with the Department of Justice, the FBI, the state police, and DPD, the 10th precinct. And it's documented, and they don't want to let me press charges.
Referencing a statute without specifying the subsection, then accusing the prosecution of misconduct with no actual evidence. It's like filing a complaint because someone looked at you wrong. In legal circles, if you're going to cite MCL 767 for all claim violations of the Michigan rules of professional conduct, you need receipts, not vibes. The judge gently warns him not to talk over the bench, yet he barrels on, convinced that volume equals validity. Spoiler, it doesn't. This is exactly why courts require structure. Chaos doesn't win cases clarity, and legal grounding.
All right, motion to dismiss is denied. I don't have the authority to dismiss the case. The issues you raised, sir, are more properly brought before the judge who's going to hear this case, which will be Judge Bryant, and you can raise those issues at your next hearing. What I will do at this time is set bond as follows. Counsel, what was your request?
People were requesting $1,000 cash as a result of the actions in this case.
Okay.
I object. He just said outside. He's being vindictive, Your Honor. I object.
Sir, do you have any financial means with which to post a bond of any type today?
I have $300 on one credit card, and I have $40 on another card, sir. And I'll be more than happy to give you whatever I have. I've been trying, Judge. I have tenants. I have my home. I have kids I need to get home. I haven't been a threat to the community. People have been lying on me, Judge. And it's well documented, man. And I told myself on personal report. And again, I object under UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not.
The alleged offense? Spitting on a police officer during transport. That's not just disrespectful, it's legally categorized as assault. And while the defendant continues pushing for venue changes and jurisdictional dismissals, the prosecution is focused on one clear act of aggression. Courts are not swayed by philosophical declarations or decade-old grievances. They want facts tied to present-day behavior. The irony, while he claims to be wrongly targeted, he's undermining his own credibility by interrupting, rambling, and bringing up statutes like 18 USC 241 and UCC, none of which apply to a basic assault charge.
To the court, Foy versus City of Berea, 58 Federal Third.
Sir, I don't mean to cut you off, but I do not have the authority to dismiss as you requested. So it doesn't do any good to give me all the citations. You can raise all of that with Judge Bryant on your next court date, okay? So court's gonna set bond at $1,000, 10%. That'll be $100 to you, sir, which you've indicated is an affordable bond.
I got my
And
card.
yeah,
Yes, sir.
if for whatever reason you don't post, you'll have an affordable bond hearing tomorrow morning. But if you do post, you don't have to worry about tomorrow morning. Your next court date will be in front of Judge Bryant on June the 7th, here in 36th District Court for a pretrial, and I'm sure that she will entertain your
Portion is more therapy session than legal defense. The defendant talks about his release from prison, being a father and grandfather, and ongoing grievances with prosecutors and law enforcement. And while it may sound compelling emotionally, it holds no weight in a legal sense, especially without documentation or proof. Courts deal in present charges, not past frustrations. Selective prosecution claims require demonstrable patterns of unfair treatment, not just suspicion. And demanding common law hearings while facing statutory criminal charges, that's a legal non-starter. His words reflect frustration, yes, but not a viable
I would like to state this, that the prosecutor is under oath under Article 6, Section 3. Right now, they're violating their oath. There is a case called U.S. versus Will. When they have jurisdiction to act and they don't act, and if they don't have jurisdiction to act, it's treason against the U.S. Constitution, sir, under the common law. I ask that you send this matter to the Michigan Attorney Grievance Commission judge because of misconduct on Kim Worthy and her subordinates.
Okay, sir. Again, that's something you can raise with Judge Bryant when you see her in June. Also, with regard to the bond redetermination date, that will be Wednesday, should you not post. If you post, you don't have to worry about it. If you don't post, that will be bond redetermination on Wednesday morning in front of Judge McConico here in 36th District Court. Thank you, sir. You can step aside.
And now for the ultimate contradiction. After 10 minutes of ranting about how the court has no jurisdiction over him, what does he ask? Do you guys accept credit cards? Let that sink in. Nothing confirms submission to court authority like trying to pay them with Visa. It's moments like these that show the true irony of sovereign citizen logic. When push comes to shove and freedom's on the line, they'll swipe plastic faster than you can say you CC1 to 308. This wasn't just a procedural slip, it was an unintentional admission that the system he denies, he also
all lowercase letters, 2305648. Mr. Creer's charge of count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, and 9, weapons, felony firearm. Also count 10, weapons, felony firearm. Set for a motion here today. Appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
Mr. McCreary, say your name, please.
Colonel Michael McCreary Ill, all lowercase, acting appropriate for signing under the Michigan Constitution 1963, Article 1, Section 30.
Here's where the entire defense collapses. The defendant argues the charges are too old, 6.5 years to be exact. But Michigan law gives prosecutors 10 full years to bring charges like assault with intent to commit murder. So he's not just wrong, he's legally irrelevant. The very statute he invoked, MCL 767.4, actually undermines his claim. This isn't a technicality, it's a fatal flaw. You can't argue expiration when the clock hasn't even run out. It's like showing up to a party and complaining it's over before the DJ even plugged in. The judge doesn't even need to respond, his own logic folds on.